Session, middle of page 1, Tracy Nugent Heath versus Daniel Heath.
For the record, this matter is before the courts. The objections, the referee recommended order filed by the plaintiff Tracy Nugent Heath to a recommended order that the friendly court holiday schedule be adopted, and that plaintiff mother and the minor child attend counseling at family counseling shelter services. This hearing this morning is being conducted via Zoom. It appears that Ms. Nugent Heath is present. Good morning, ma'am.
Good morning.
Is Daniel Heath present?
Yes, sir.
All right. Good morning, Mr. Heath.
Good morning.
Heath is present on audio. The two of you have conferred with Mr. Pratt for the front of the court this morning, who has provided the court with the following recommendation. The recommendation is that the recommended order be adopted but modified, namely, the judgment of divorce is noted that it's a mute as to physical custody. The parties agree that they should share joint legal custody and have reasonable livable parenting time schedule. Obviously, legal custody means the two of you share equally any major decision concerning the welfare of your child, elective surgery, education, religion. If the child goes to emergency, you need to immediately notify the other parent when it occurs on your time. People get hung up on the term physical custody. It need not necessarily be addressed. It's the recommendation is that some of the parties shall continue to share joint legal custody, have liberal parenting time. The parties shall participate in family counseling, and the parties shall follow all recommendations of the counselor. That is a recommendation. Ms. Nugent Heath, do you understand the recommendation?
I'm sorry?
Do you understand the recommendation this morning?
Yes, I do.
Do you have any objection to the court adopting the recommendation?
No, I do not.
Okay. It's pretty standard. If the parties cannot agree upon dividing holidays, the court will always adopt the front of the court holiday schedule as a fallback. Obviously, the two should work out. If, for example, if one parent celebrates Christmas Eve with their family and the other is Christmas Day, then you should work together rather than alternate that. Try to make it work for each other and your child.
Yes, sir.
Mr. Heath. I'm sorry, ma'am.
I agree to that. The reason I had filed it was because I wasn't able to see my son over the holidays.
Okay.
And that's why I wanted the adoption of the holiday schedule. Something put into place for me to have it in writing.
Okay, well, of course, surprised that was not in your judgment. Typically, the attorney do provide for that, the fallback being the front of the court holiday schedule. But of course, this recommendation, do we need to specifically reference that in this recommendation, Mr. Pratt?
Your Honor, because we adopted the referee recommendation, we should be all set. But if you want me to reiterate it, I certainly can.
No, I see what you mean. So yes, by adopting this recommendation this morning, for the referee does recommend that the court the parties adopt and follow the front of the court holiday schedule. You can get that online. So yes,
Your Honor,
appears to cover that. Yes, Mr. Heath.
I'm sorry to interrupt. What was agreed upon in the marriage, the divorce thing is it was up to Mason's choosing. Like it was what Mason when and where and how he wanted to do it. And that was a big deal for me. And that's why it's worded in there the way it was, is because it's up to Mason of when and where he wants to be. And I feel like Tracy's now trying to make it like a legal thing and switching it up after the fact is how I feel.
Well, Mason is a minor. The minors don't drive the bus. It's the parents. So the judgment of divorce says the parent time will be as agreed by the parties, not as determined by the child, it's stipulated by the parties. Obviously, as Mason gets older, yes, both you're going to put more weight on his input. If he has an activity with his friends or an extracurricular, you're going to try to accommodate that. And obviously, when he gets to be upper teens, but he's still a minor. So, for example, Mason can't say, "Dad, I don't want to see Mom." It's not his call. He needs a relationship with both parents. So this is the call of the parents. Yes, as he gets older, you're going to give more weight to his preferences. But obviously, each of you encourage good relationship between Mason and the other parent. And I don't want to see mom. It's not his call. He needs a relationship with both parents. So this is the call of the parents. Yes, as he gets older, you're going to give more weight to his preferences. But obviously, each of you encourage good relationship between Mason and the other parent. And I've got your judgment in front of me, Mr. Ethan. It does say parenting time would be as agreed to by the parties, not as determined by the minor child.
He's 16 and a half, so he's coming up on 17. And Mr. Godfrey specifically told Mason that it was totally up to him when and where he wanted to be and visit. And then that was told to me when we were doing the divorce, and my lawyer specifically told me that Mason got what's best for Mason, and it's up for him to choose. And that's how it was worded to me and Mason specifically. And like I say, he's 16 and a half. He is getting to be the upper teens.
Well, clearly his preferences obviously will carry a lot of weight between the two parents, but Mr. Godfrey, I'm looking at the language in the judgment divorce. That's what controls, not what some third party told you, your lawyer or a mediator. It's what's in the judgment divorce, and it does provide it's an agreement between the two of you. So work together. And yes, obviously before you know it, Mason's going to be on his own. And right. Yes, as he's getting 16 and 17, there's no question he's going to have his own activities. He may have employment. So it's going to force both parents to work around his schedule. The reality. So without question, it's a practical matter, Mr. Heath. Mason's activities will dictate a lot of the parenting time. You're not going to deny him some activity that he enjoys because it's your time and you don't want him to participate in the activity. So that's the court clearly understands where you're coming from, but ultimately it's the two of you that needs to communicate for his best interests. So with that, Mr. Heath, do you have any objection to the court adopting this recommendation?
I don't think so, but I do want it to be noted that I haven't never agreed to this divorce agreement. I've never signed my name. I've never told anybody I agree with it. It's totally been forced down my throat.
I do see that you did not sign this judgment. Obviously, it was submitted under 7-day rule. And obviously, if in fact you had issues, and discuss that with your attorney. You were represented by a very capable family law practitioner, Mr. Gorski, throughout these proceedings.
And once I ran out of money, I haven't even had contact with her, to be honest with you.
Okay. Well, your position is noted, Mr. Heath, and obviously Mason's going to be an adult before, and then blink of an eye, he's going to be on his own. So continue, but the reality is that you and Miss Heath have tied together for life because of Mason. There'll be significant events in the future, college graduations and weddings and so forth. You both need to be part of his life. So continue to work together for his best interests.
We'll definitely do that.
All right. Okay. Well, it sounds like the two of you are on the clearly want to do what's best for Mason. So please communicate for his best interests. And with that, the court appreciates both of your input. The court understands where both of you are coming from. The court will adopt the recommendation of Ms. LaPrade this morning. You both emailed a copy of this.
Thank you.
Okay. That will conclude this hearing. You can both zoom out. Have a good rest of the day.
Thank you.
You too.
You're welcome. Walked to the post office this morning. Guess what I heard? All the chickies.
Aww.
You know, their packaging boxes time of year were being sent out through the mail.
Yeah.
Box of chicks.
Yeah.
Little baby chicks. Yeah. You can hear them. They're all chirping in the back. Yeah.
They send those through the mail?
Yeah. Yeah.
Never heard it.
They'll bring a few in.
Wow.
That starts sounding springy.
So cute.
Yeah.
Okay, we're good now. Okay. Court is now in session, top of page 1, Tori Carrier versus Elena Peer.
For the record, this matter is before the court for the purpose of reviewing plaintiff father's parenting time. This hearing is being conducted via Zoom. President St. James Petrangelo representing plaintiff father Tori Carrier. Mr. Carrier was here just a moment ago. Mr. Carrier, can you hear the court?
Yes.
Okay, good morning. Also present Attorney Lowry Rains representing defendant mother Elena Hare. Ms. Hare is present with Mr. Rains. The parties have conferred with Ms. Andrus from the front of the court this morning. Good morning, Ms. Andrus.
Morning, Your Honor.
The court has received the following recommendation. The recommendation is that parenting time for father shall continue as previously ordered, but shall be supervised by the maternal grandmother or grandfather, whose last name is Bosky.
Yep.
And further, that the parties appear backwards court to review father's parenting time on April 30th, 2024 at 9:30 a.m. That is the recommendation. Mr. Karen, was this recommendation agreeable with your client this morning?
It is.
Okay. The average parenting time is alternating weekends, Friday after from school to Sunday at 6 p.m. and alternating Sundays, 9 to 6. Is that correct?
That is correct.
All right. Mr. Raines, is this recommendation agreeable with your client this morning?
Your Honor, it is not. We do have concerns. May I raise those at this time?
Yeah, so the only difference in this recommendation is that parenting time now be supervised. Before today, the parenting time was not supervised. Is that correct?
That is correct. Yeah, my understanding is that is the only change, and that there is a further review hearing that would be scheduled. Your Honor, and while I do appreciate that aspect of the recommendation, our concern is based upon the fact that we filed this motion for change of custody back last spring. Since that time, Mr. Carrier has been charged with a domestic violence offense in July 2023 against that matter has remained pending as a domestic violence second offense. And just within the last 8 days, there has been another domestic violence second offense that Mr. Carrier has charged with. Mr. Angela was not aware of that prior to today. It appears to have been misinformed by his client, authorized, but I believe we confirmed there are new charges on March 5, 2024 incident wherein it is alleged from the sheriff's report that we have a copy of that he had assaulted this same person who he had assaulted before, and that this was during an overnight, suggesting that they are living together, they are staying together, that he had grabbed her by the back of the head, throat, and she could not breathe. She managed to escape from Mr. Carrier, according to the narrative report. However, Mr. Carrier pursued her with his grandfather, the same Mr. Bosky, who is being recommended to do supervision of Mr. Carrier. This is someone whom he lives with. This person was a witness to this incident, has not been interviewed. I do not see a report of an interview report on this. I do not know what his position is regarding that matter. I do not know if there will be any investigation of him regarding his involvement in this matter, but it appears as if he was at least to some extent complicit in pursuing, in facilitating Mr. Carrier pursuing this victim after Mr. Carrier had assaulted her. So the behavior that is not only concerning, but that is unlawful and outright illegal of Mr. Carrier continues to this day. And to have the parenting time continue with simply having the grandparents continue to watch him, whom he's lived with, and he is engaged in this behavior historically, and as well as 8 days ago, he's been in that same environment. To have them supervising the parenting time, I think, is not clearly in the best interest of these children. Parenting time, we have suggested, should be supervised. I frankly do not believe it should even be on an overnight basis at this point. I don't know why he was angered in the night and assaulted his girlfriend, but it should probably be on a non-overnight basis with supervision from somebody other than those persons, perhaps through another agency. Mr. Carrier has related to us at the front of the court hearing something different from what occurred in this incident. However, I think he will candidly advise the court that he was in this incident robbed and punched in the face by this person who is identified as being the victim in this report, suggesting that there is turmoil, there is violence, there is chaos perhaps in the home of Mr. Carrier, and problems that have not been brought to the attention of my client. So that with those problems in the home, with children being exposed to that, it's not in their best interest. And Your Honor, for those reasons, we respectfully request that Your Honor consider supervised non-overnight parenting time on simply alternating weekends. Not every weekend, where as what he has presently. He presently has the Friday at 6 to Sunday at 6 on alternating weekends, but also has from 6 to 6, which is preventing my client from having any any full weekend with her 3 children, whom she's been caring for and doing excellently with. The children have been thriving at the Blissfield schools, where they have been doing very well in school. In fact, the youngest child, I think it's the youngest child, his grades have even been improving, and his behavior has been improving since she's been really acting as their primary caretaker since approximately May of 2023 at this time. So, Judge, the problems continue with Mr. Carrier. You don't have to look any further than 8 days ago to find out what happened. And again, he hasn't even been candid with his counsel in discussing the incident that recently happened. So, Judge, we'd ask that there be supervised visitation. Thank you.
Thank you, Mr. Raines. When did this most recent alleged incident occur? What month?
On March 5, 2024.
Has there been any authorization, to your knowledge?
Yes, it has been authorized, Your Honor. I think that's been confirmed through the friend of the court. Your Honor can confirm at this time. Presently has a pretrial conference scheduled before Hearing Officer Brown on April 25, 2024 at 9 a.m. The charge is domestic violence second offense. I'm sorry.
So there are 2 pending charges of domestic violence second?
Yes, Your Honor. The other one relates to a date of offense of July 22, 2023.
They're both pending?
Yes, Your Honor.
Do you have that case number?
I believe that the case number on that other one is 2020. That is presently scheduled. Perhaps Mr. Carrier will confirm. My record shows, well, I don't have a next hearing date, but that is, I believe, malicious destruction of property as well as a domestic violence as well.
Okay. Did they, and they both involve the same victim, is that correct?
They both do those other 2, the final 2, yes. The one that happened in August of 2022, which predated our filing this motion. That one is of a different victim, but yes, the July 23 and the March 5, 2024 involve the same victim. That is a Miss Brianne Pirwitz, Pirrwitz.
Were the children present during either of those incidents?
According to the incident report, they were not present during those incidents. I don't believe.
Obviously, the behavior is concerning, the alleged behavior, Mr. Raines, but the primary concern of the court is that the children were not exposed to this. And you would agree that children were not present during the July 2023 or March 2024 incident, is that correct?
I cannot confirm on the July 2023 incident, but I believe my client had the children in her possession as it was a weekday during the most recent offense 8 days ago. And yes, Your Honor, the offense date was 7/21/2023. It is a domestic violence second offense, and that matter does remain pending, as I understand it.
The court, of course, was aware of a domestic violence prior one back in 2022 involving Mr. Carrier and his girlfriend at that time, Carly Frampton. The court file notes reflect that. But the court was not aware till just now of these 2 additional charges, which are concerning. Mr. Petrangelo.
Yes, Your Honor. First of all, as to the earlier charge, as indicated, this has been aware throughout all of our discussions since last summer, including when Ms. Scott interviewed the children and made a recommendation that they return to week on, week off parenting time. We've gone along as these things pended. And in fact, that charge was dismissed. It was reauthorized, and that's apparently what the police relied on to arrest my client on March 5th. And that's what he indicated to me, that the officer said, well, you've got an outstanding warrant. And it turns out that's what it was, reissued charges. As indicated, this happened on March 5th. So that's a weekday. Children were not present. My client's version was he was robbed and his car taken. That was Mr. Boxey's involvement to try to help him go back and get his car back. Mr. Boxey's testified before this court before. This goes way back. The And in the past, when we've required supervisors, that's who we've used, he and his wife. It is also important to note that all of these allegations by this alleged victim have never resulted in these matters before the court or being brought up in any convictions. So we don't know that there's going to be again, these are things not happening in the presence of the children. My client had indicated the daughter very much wanted to talk to the front of the court with her complaints on what's going on with in mother's home. We raised that. I think under the circumstances, I understand the front of the court's recommendation. Let's get past this first pretrial so we can all get more information about what's swirling around here and see. But so I think while we don't believe this supervision is even necessary, we are willing to go along with the recommendation. We do not want mother trying to, the child's already requesting more time with dad. We don't want her to use this as a reason to try to frustrate and make that visitation difficult with father. And that's what she seems to be trying to do.
But my client is not trying to frustrate any of the parenting time. It's Mr. Carrier who finds himself crosswise with the law once again following an incident that happened just 8 days ago, where I know Your Honor is very well aware of MCL 722.23, the best interest of the child factors, and the court is aware of factor K related to domestic violence, which states that domestic violence is a concern of the court, regardless as to whether it's occurred in the presence of minor children or not. We have an incident where Mr. Carrier is acknowledging, as stated by his own counsel, that there was an incident of domestic violence that occurred. He was attacked by his girlfriend, he's claiming.
Not my girlfriend.
Happened in his home. It's not his girlfriend now. I'm sure they're bond conditions, but that there was an incident of domestic violence that occurred within the Bosky's home with Mr. Carrier. So there you have already before you domestic violence that's happening, that's affecting his relationship with other people. That is a concern that the legislature says should be addressed, and that certainly should be a concern that this court has as to whether it's appropriate with somebody with this type of a history. And frankly, there's a conviction in Lenawee County in 2017 of Mr. Carrier that relates to his child being injured because of his behavior. This is a child of Miss Harris back then. But this is not my client trying to frustrate any parenting time. Rather, she wants to facilitate healthy parenting time with a supervisor who would be appropriate. Certainly not Mr. Bosky, who is driving out with Mr. Carrier in the immediate aftermath of an incident wherein he assaulted his then girlfriend. So I do think, again, that supervised parenting time is appropriate. Your Honor, there was one other matter that was addressed by my client, and that's counseling for the minor child Harmony. I think she is the eldest of the children. She's 12 years of age, and my client is requesting that the child be able to participate in counseling through Catholic Charities. She has raised today that there is an informed consent for treatment form that Mr. Carrier would need to complete, as he is a joint legal custodian of that and the other children. Mr. Carrier is, as I'm understanding it, refusing to do that. The claim is from Mr. Carrier is that this is being raised belatedly to him and that he wants to have an opportunity to talk to the child first, seemingly to convince her not to go to counseling, when he acknowledges earlier today that that child supposedly is miserable, which would seem to suggest counseling might be appropriate for the child, so we can get to the bottom of what Mr. Carrier believes to be is that child's misery, whether that be caused environmentally because of my client or from Mr. Carrier or neither, but the counseling would seem to be appropriate. The thought is, well, we need to wait some time and let me speak to the child, and let's have these parties communicate and talk about this. Your Honor knows well that when there's a history of domestic violence between parties, as well as there's active domestic violence that's happening, communication can sometimes be difficult, and I can attest, and perhaps the front of the court will indicate as much even here this morning, that these parties were exchanging words and Mr. Carrier was raising his voice during this. It's very difficult for my client to communicate effectively with Mr. Carrier. Quite frankly, she's trembling even as I'm speaking with her, as she's present with me right now, because of the difficulty that she has in being able to have a much conversation with him. So that's the reason it's been raised at this time. We'd like to see at least that minor child harmony also get into some counseling. Thank you, Judge.
All right. Thank you. Just for the make sure the court understands, Mr. Petrangelo, the incident of July 2023, that was dismissed and then reauthorized in March.
That is my understanding. I don't know what the date it was reauthorized.
Right. Do we have one incident of domestic violence or two?
I'm being told, I was aware that Mr. Carrier was rearrested on a reauthorized charge. Now I'm told by Mr. Raines that about this incident on May 5th or March 5th, and this is the first time I heard that there's a charge issued for that. So I'm taking Mr. Raines at his word that that's reauthorized. My client, all he knew, he is arrested on the reissued charges. Again, this did not happen with the children, did not happen on a parent.
Understood. I'm just trying to understand, do we have two incidences or just one?
Mr.
Raines, this incident that you have a police report in front of you, was there an alleged domestic violence on May 5th of 2024, or was he rearrested for a July 2023 incident?
Judge, there's an alleged incident that occurred on March 5 of 2024, wherein Mr. Carrier would have grabbed Ms. Reed.
All right.
The grandfather filed. After that, I thought I indicated to the court the specific case number if you wish to check that on the ROA.
Yeah, no, that's fine. It's a new incident. It's a separate and apart from the July 2023 incident. Is that correct?
That is correct.
Gotcha. All right. Mr. Petrangelo, any objection to the minor child harmony engaging in counseling?
Your Honor, probably not. What we stated is the parties have joint legal custody. This is something that apparently mother has looked into, made arrangements, selected somebody, set up an appointment without even alerting us. Mr. Carrier simply said, I'd like a chance to check with this, talk to this counselor, see what it's about, talk to my daughter, and I may agree. And that could have easily been avoided if even if through Mr. Lowry Raines, we'd been alerted. So my client could have done this in advance of today. We got hit with this a few minutes ago. And so, no, under these circumstances, it certainly seems like something's trying to be orchestrated. That seems unfair.
The court believes any professional counsel will be able to sort through that. Obviously, Ms. Hare, do we know the name of the proposed counselor, Mr. Raines?
Can Ms. Hare address you? I do not know it myself.
All right, so the court's going to order that the minor child harmony be enrolled in counseling. Ms. Hare, you shall immediately notify Mr. Carrier of the name of the counselor and the agency so that he can reach out to that counselor. There's no need for dad to talk with Harmony to see why she needs counseling. Any parent that believes that a minor child needs counseling, there's no harm in that. So the court will order that Harmony be enrolled in counseling. Ms. Hare, you need to, want to identify the counselor, you need to notify Mr. Carrier of the name and
Your
agency
Honor,
that this counselor works for. With respect to, who else, Mr. Petrangelo, does your client live with?
He lives with the Boxies, Your Honor.
Okay, no one else? No
Mr.
girlfriends, no significant others?
no. But Your
Right.
Honor, I didn't want to ask her why she wanted to go to counseling or anything like that. I just wanted to make sure that's what she wanted because she has done this before and forced it upon my other child and he did not like it. And I just wanted to make sure my oldest daughter was okay with whatever. I don't care if she wants to talk to somebody. That's fine.
This court has determined it'd be appropriate. You can talk with the counselor, and then if you have to talk with the counselor says your daughter doesn't need this. I don't know why you're wasting my time. Then you can bring it back before the court through Mr. Petrangelo. But the court's going to order that Harmony be enrolled in counseling, and that Ms. Hare immediately promptly notify Mr. Carrier of the name of that individual and agency and the location of that counselor.
Yeah, normally they call me.
Presumably, Mr. Raines, there's a bond condition, then presumably in place, Mr. Trangelo, that this victim not be, or Mr. Carrier not have contact with this victim. Is that correct?
Your Honor, I do not have that
Okay.
information, but I would presume that there's a bond condition in fact.
I would presume it as well.
Okay. Right. Due to the fact that the court fully understands the position, the court's obviously concerned about Mr. Carrier's history. Is he currently involved in any anger management program, counseling programs, Mr. Petrangelo?
Not that I'm aware.
Okay.
Of course, he was just arraigned on all of these things at the end of last week. So,
well, but he was arraigned back in late, sometime in mid 2023, was he not, on a domestic violence program?
but that was dismissed, Your Honor.
Okay.
He was just arraigned on that now.
So that was authorized and dismissed within a month?
The matter in 2023 was dismissed, and I know it had been dismissed when we appeared here back in December. That charge had been dismissed. So so this is something that was reauthorized later, and so there was no bond condition in effect during all this time until last week, when this latest incident came up and the police used the reauthorized warrant to arrest him. And apparently, if I accept what Mr. Raines is telling me, and I do, then at that point, this new charge was issued.
All right. All right. So due to the fact that the court has significant concerns, the court recognized that the incident unfortunately did not occur in the presence of the children, but obviously Mr. Carrier has some issues he needs to address. So at this time, the court will adopt the recommendation. Mr. Raines will be back in 6 weeks. The court can address that. The court will simply add to this recommendation, again, that the parenting time be supervised by the paternal grandparents. So Mr. Carrier, one of those grandparents have to be present at all times the children are with you, all times. The court will also order that Mr. Carrier immediately engage in anger management counseling. He needs counseling. And if he's not actively involved in anger management counseling, when we come back on April 30th, the court will modify parenting time. And whether it's going to exercise parenting time with an agency or stopping the overnights. So Mr. Carrier needs to promptly make that appointment for his own welfare and benefit of the children. Further, the court will add to the recommendation that Harmony be enrolled in counseling and that mother promptly notify Mr. Carrier of the identity of that counselor. Anything further this morning, Mr. Raines or Mr. Petrangelo?
No, very good. Thank you, Your Honor.
No, Your Honor.
Okay, Mr. Anderson, we're going to add a couple of those things to recommendation. I would appreciate that. That will conclude this matter. We'll see you then on April 30th at 9:30.
All right. Thank you, Your Honor.
Thank you, Your Honor. Thank you, Mr.
For the record, this matter is before the court on the objections of Crystal Beck to a referee recommended order of child support. Recommending child support in the amount of 0 as of January 1st, 2024, due to the inability of the defendant father to work. Good morning, Ms. Brower. And
good morning, Your Honor.
This hearing has been conducted via Zoom. The plaintiff, Crystal Beck, is present. Is Anthony Letourneau present in audio?
Yes, I'm here.
All right. Good morning, Mr. Letourneau.
Morning, Your Honor.
Mr. Letourneau, are you still facing a pending felony non-support charge?
That's correct.
Okay, what's the status of that?
I don't know what you mean by tabs with that, Your Honor.
Have you been, is it still pending? Is there a trial date set? Have you entered a plea? Are you waiting sentencing?
Okay.
What is the status of that felony non-support charge?
Sorry, Your Honor, I got you down. It's still pending.
Okay. Have you applied, your social security claim is still pending, is that correct?
Yes, Your Honor.
Okay. How do you support yourself?
I don't.
Well, come on, hold on, Mr. Turner. Someone's putting food in your feeding you. Someone's putting a roof over your head. Who's doing that?
The friend that's let me stay here.
Okay, so a friend is putting you up for free and also feeding you. Is that correct?
I get food stamps now through the state of Michigan.
Okay. What?
And health insurance.
So what's your physical disability? Do you have a back problem?
Yes, Your Honor. I got legs problems, back problems.
Okay. Well, could you get like a job at a clerk at a gas station that you can be seated, you can stand when you need to, and then move around? A job that does not entail lifting? I'm just trying to determine if you're 100% disabled. The front of the court is a 4-page list of employers, and some employers it's just a desk job. Are you disabled from a desk job?
I got no experience in desk jobs.
You don't need experience. I'm thinking, for example, at a gas station where you're in a booth, and people come up and they want to buy some cigarettes or they want to pay cash for their gasoline. Is that something you could do in light of your disabilities?
I just can't stand for a long period of time.
Say, assuming you have a chair right there, you can sit and stand. They can be seated at a gas station booth. Right. The parties have before Ms. Brower for the front of the court. Ms. Brower is recommending that referee recommended be adopted. Ms. Brower, it sounds like Mr. Letourneau is not 100% disabled. He can do something. And maybe that's why Social Security is not acted, because he's not 100% disabled. I've not seen the claim.
Your Honor, he did testify with Mr. McKee that he has a heart aneurysm, asthma, COPD, nerve and back issues. He stated that he is seeing his doctor, I believe, every few months. He didn't have a doctor's note in his possession right this moment, but he said he will provide one to the front of the court that states he's unable to work.
Mr. Letourneau, what's your next court date in the felony non-support charge?
April, I believe it was.
Okay. Aren't you making child support payments in the interim while this charge is pending? Because you have arrearages. Arrearages is not going to go away. We're just talking about current support right now. But aren't you paying something toward your child support arrearages while this charge is pending?
I can't, Your Honor. I don't have no income.
But do you own any assets? I mean, they're not going to go away. You could be putting
I know that.
If you're convicted,
I know that, Your Honor.
You're required to make regular payments, Mr. Letourneau.
Yes, Your Honor. I know that. To answer your question about assets, I got nothing in my name. No house, no cars. Only thing I own in my name is clothing.
Okay. You say, do you own other assets that are not in your name? For example, do you have an automobile that's in someone else's name?
No, I got nothing like that.
Ms. Brown, the court adopt this recommendation. Would the front of the court still monitor that felony non-support matter?
Yes, Your Honor.
In fact, Mr. Letourneau does not get approved for Social Security, he needs to start there. I think it sounds like there's something that Mr. Letourneau can do. Some line of employment. I don't see any medical reports that he can't sit at, for example, a booth at a gas station.
We will monitor for enforcement after adjudication of that felony non-support.
All right, Ms. Beck, I certainly understand your concern. These words are not going to go away. And yes, you're the one that's supporting your 12-year-old son. Mr. Letourneau, he may end up going to prison unless he makes some payments while his charge is pending. I can't believe he's not making payments. And I'm sure his attorney should be telling him, Mr. Letourneau, make some payments and do something to avoid a prison sentence for this felony non-support. But certainly we'll monitor this. And if in fact he's a period of time goes by and he's not collecting Social Security if it's not been approved, then the court's can order him to secure some line of employment. Miss Beck, is there anything else you want to add?
Nope, I've already said everything I can say. I don't understand, as you have pointed out, he could sit at a gas station. I even explained to the referee, there are jobs he could do from home on a computer, but he chooses not to do that either.
What about that, Mr. Letourneau?
I don't have a computer, Your Honor.
Well, so what do you have? Do you have an iPhone that you're calling in from this morning?
No, Your Honor.
So, but whoever you live with has a computer they have access to, correct?
Actually, no, not here. They don't, Your Honor.
Okay, I'm sorry, I don't understand. Right now, you're engaging with the court via Zoom over a computer. Is that correct?
On the phone, Your Honor.
Oh, on the phone. So, whose phone is it?
It's theirs.
Okay, you don't own any phone?
Nope. Again, Your Honor, no money.
Well, I understand you don't have money, Mr. Turner, but the court is hard pressed to find that you are not capable of some type of employment. I got a 4-page list I'm going through. How about you could be a cashier at a gas station? I mean, mobile tell you right now, $13, $15 an hour. Why can't you do that?
Well, I don't have no license. I can't stand very long, and there's no gas station within walking distance. And like I said, I can't walk at all without using a walker. I can't go in a grocery store. I got to use a grocery cart, or sometimes I got to use the scooter to get around.
Yeah. Ms. Brower, has your office received any medical documentation other than Mr. Letourneau's self-serving statements? Has your office received any documentation?
We received documentation regarding his Social Security claim. He believed that he had submitted medical documentation with that Social Security claim, but we do not have it. He said he would provide that to our office.
All right. All right. At this time, of course, going to continue this matter. Maybe sometime in late April, Mr. Letourneau, the court's going to order you provide medical documentation to the front of the court prior to the next review date. That means letters from your doctor says that you are 100% disabled. You can't do anything. We need some medical documentation, not your self-serving testimony. You have a child here that they brought in this world you need to support. And when you bring that documentation in front of the court, pick up a copy of the 4-page list. Quality and suites, looking for a front desk receptionist. You can sit at a front desk. And why don't you have a driver's license?
The court's suspending it.
For what reason? For not paying child support?
Correct. That's what you guys did. Yep.
Well, that's something that you brought upon yourself. I'm sure there's got to be someone you can find that can drive you to and from work. But I want you to provide medical documentation showing to this court right to the front of the court prior to this next review hearing dates. So the court at this time is going to adjourn the hearing in this matter, Ms. Brower. So we're going to give you another date to come back, Ms. Beck, and the court wants Mr. Letourneau to provide documentation in front of the court that he is 100% disabled, even though the Social Security has not yet made a determination. I'm sure he's got letters from his doctor. We'll adjourn this matter to April 30th at 11 a.m. So, Mr. Attorney, the objections will be filed by Ms. Becker. That will be adjourned to April 30th at 11 a.m. And we'll mail you a copy of this notice. But between now and then, you need to provide for the court with recent letters. Not a letter that was dated 6 months ago, but something that's recent, since the first of the year. Your doctor says that you're incapable of any type of employment. Any questions, Mr. Letourneau?
Nope, I got you, Your Honor.
And I'm sorry, when's your next court date on the felony non-support? Pre-trial, April?
Your Honor, it's April 26th.
All right.
26.
Okay, April 26th. So we'll have a better understanding of what's going on and come back April 30th.
Page 2. Crystal Beck versus Anthony Letourneau.
For the record, this matter is before the court for adjourned hearing on the plaintiff Crystal Beck's objection to a referee recommended order of child support. This hearing is being conducted via Zoom. You, Crystal Beck?
Yes, sir.
Good morning. Is Anthony Letourneau present on audio?
Yes, Your Honor. Morning.
Good morning, Mr. Letourneau. The two of you have met with Ms. LaPrade this morning. Ms. LaPrade is recommending that the referee recommended order be adopted. If the court recalls, the recommended order of child support was 0. Is that correct, Ms. LaPrade?
That's correct, Your Honor.
It's alleged that Mr. Letourneau unable to work due to medical condition. Mr. Letourneau, are you now receiving Social Security?
No, not yet, Your Honor.
Do you have a hearing?
I got a lawyer for that, and everything's going through her.
But there's no hearing date scheduled?
No, not yet, Your Honor.
When you were last before the court back in April, or previously, the court ordered that you provide medical documentation to the front of the court that you're 100% medically disabled of any type of employment. Have you provided that documentation?
Yes, Your Honor.
Right, Mr. Pratt, have you received such a documentation that he can't even sit at a desk job, a clerk at a gas station?
Your Honor, we do have a letter from his physician stating due to his disabilities, he is unable to work.
Okay. Okay, do you understand all this, Ms. Beck?
I do, sir.
Mr. Letourneau, you're still facing a pending charge of felony non-support. Is that correct?
That's correct, Your Honor. Just had court last Friday on that.
Okay. Of course, so the arrearages, I think they're about $16,000. The court's action this morning will not affect those arrearages. You understand that? Mr. Letourneau, do you understand that?
Your Honor?
Yes, do you understand you still all these arrearages?
Oh, yeah. Oh, absolutely.
And how do you intend to pay those?
Once I get my disability, Your Honor.
Well, how right now are you buying groceries? How are you paying utilities? Who's supporting you?
My groceries is through the state of Michigan. I got food stamps. I got insurance through the state of Michigan. And that's all I got.
Well, you may be a prison candidate, Mr. Letourneau. If you don't start paying toward these arrearages, you could be find some time in prison.
Oh, I know, Your Honor. I know.
Ms. Beck, you probably want to pay close attention to the pending felony charge and let the judge know that he's not paying anything toward arrearages.
I am in contact with the Attorney General for their proceedings as well, Your Honor.
Yeah. Again, even though he's got a physician's letter, it seems to the court that Mr. Letourneau could do something. He's got a mind, he's got a voice, he can do something, even if it's a job on his computer. There's something he can do to secure some income. In any event, the court is inclined to follow Ms. LaPrade's recommendation. Anything further, Ms. Beck?
No, sir. She gave me the information I needed.
All right. Ms. Letourneau, any other questions?
No, Your Honor, I don't think so.
All right, court will adopt the recommendation. The child support will be at 0, but you still owe those arrearages.
Correct.
And the court would suggest you start paying something on that if you want to avoid a prison sentence.
I understand, Your Honor.
That's it. That concludes here, and you can zoom out. The record of this matter is before the court on the plaintiff's objections to a referee recommended order regarding child support, the plaintiff being Madison Blade. This hearing is being conducted via Zoom. Is Madison Blade present on audio?
Yes, I am.
Right. Good morning, Ms. Blade. Is Torian Evans present? It appears that Mr. Evans is not present. Ms. Blade, you object to a recommendation of child support of $286. You're alleging that the father does not consistently exercise 3 overnights each week. The number of overnights has a small bearing on the amount of child support, but not significant.
Right, and that doesn't matter to me.
Okay, you met with Miss Andrus from front of the court. Miss Andrus has recommended that the referee recommend order be rescinded and canceled, knowing that Mr. Evans did not appear today, and that child support shall be in the amount of $506 per month, with an effective date of July 1st, 2023, rather than $286 as previously recommended. Do you understand the recommendation?
So that it's going back to the original order that was sent to me in the mail that he will be paying $500 a month now?
I don't know what the original order said, but the recommendation today is that that the new order entered in the amount of $506 per month be adopted with an effective date of July 1st, 2023. Was that the prior amount?
No, the prior amount, I got a paper before, it was the referee's order. It did say 506, but when I called, they said that it was still 140 or something.
So it's currently charging, Your Honor, it's currently charging 143 a month, but back in November 8th, the de novo child support was referred to the front of the court for an investigation. So that recommendation came to 75 overnights, 506, dating back to July, and Dad objected to that, and that's when they went in front of referee McKee on February 6th, where Mom objected.
So I'm sure what basis did it go up from 286 to 506?
The overnights. Dad alleged that he
overnights.
had 3 overnights, and then the recommendation the front of the court did went off the judgment of support, the last order for parenting time of reasonable and liberal. So Mom was not at the referee hearing on the 6th to, I guess, negate father's 3 overnights.
Okay. So Miss Blade, how many overnights on average does Mr. Evans exercise parenting time?
When he does exercise his parenting time, it is for the 3 overnights. It is not consistently. And with that, exercising his rights to come and to get his child and spend his parenting time, he's supposed to pick our child up and bring him home. And he's failed to do that. And
So
the last 2
on
weeks,
average,
how
many overnights per week on average?
It would be 3 if he was getting him, but it's not consistently.
On average, how many overnights does he actually exercise overnight parenting time?
In a month?
Correct.
I would say 10. Unless I bring my son out there. That's the only time it ends up being,
So
that he gets it all.
Okay, that's about 2.5 nights a week. And Miss Andrus, this 506 recommended amount, how many nights overnight does that contemplate on the part of Dad?
Has the reasonable and liberal 75 overnight.
Okay.
Because that hasn't changed, and him exercising his parenting time hasn't gotten any better.
All right, Miss Blade, you signed an affidavit. You mailed a copy of this notice to Mr. Evans for today's date and time.
Yes.
Did you do that?
Yes.
Okay.
Your Honor, the front of the court also called the phone number for him we have on file, and then also the number Madison provided the court, and neither answered.
Okay. Is the front of the court address for Mr. Evans still the 15600?
Correct, Your Honor. That's what we have on file.
All right. Miss Blade, when did you last speak with Mr. Evans?
Yesterday when I picked my son up because I had to. His dad was supposed to bring him home for his ABA therapies.
Was there any discussion, Miss Blade, was there any discussion about today's court hearing date?
His father was sleeping when I went and picked my son up. And nowhere.
I'm asking, did you speak with Mr. Evans recently?
Yesterday, but it wasn't much of a conversation.
Okay, you said he was sleeping.
Yes. And then I picked my son up because he had a doctor's appointment.
All right.
At 1
so
o'clock.
was he sleeping or was he awake to talk to him?
He texted me.
Okay.
After I picked my son up one time.
Okay, was he aware of the hearing date? Was there any discussion about today's court date?
No, all he does is talk about court hearings though, so I would assume he knows about them.
All right, so seems like the 5 or 6 may be a little bit high, but in any event, Mr. Evans failed to appear, so the court will adopt the recommendation. The court will rescind the prior recommended order. Ms. Blade and child support will be the amount of $506 per month back to July 1st, 2023. I'm sorry, Ms. Anderson, what's the base for going back that far? The current support is considerably less than that, but more than what was being recommended of 286.
Mm-hmm. Yeah, the de novo. I'm not sure, Your Honor, as the front of the court, I did not do that child support recommendation. That was just what was on the recommendation dated 12/6.
Okay. But your calculation of 506 a month is based upon his stated income for Ford Motor Company when he appeared before referee McKee, that he earns $3,333 per month.
The recommendation for the 506 a month had neither party turned in their financial information on that, and it had that as his gross income is $2,335.48.
Okay, so this is a recommendation not based upon the purported on referee McKee's findings. Mr. McKee determined that Mr. Evans earned $29,000 in 2023. His current income was, gross income of $3,333.33 per month. Ms. Blade, what is your monthly income?
Is around $1,200 to $1,500 a month.
Okay, and what income did you use for Ms. Blade, Ms. Evans, Ms. Andrus?
For Ms. Blade, on which one? The recommendation referee McKee did, or the child support rec?
Your recommendation today at 506 a month.
That has Ms. Blade at monthly gross income at $404.02 a month.
$404 a month?
Correct. Pioneer Medical.
Referee McKee indicated based on the defendants, Mr. Evans has suggested that you made about $1,700 a month for Ms. Blade.
Did you repeat that? I'm sorry.
How many hours a week do you work?
I make my own hours. I DoorDash.
Okay. What's your average weekly take home?
On a week?
Yes, we're talking about you, Madison Blade.
Okay, I don't get paid weekly. Just give me 1 second.
Okay, what's your monthly income then?
For February, my monthly income was $1,400.
Okay, so we should base this on $1,400 monthly income for Miss Blade, and $3,300 a month for Mr. Evans. What does that calculate out to, Miss Andrus?
Oh, I'd have to pull up the guidelines, Your Honor. I did not have those prepared.
Right. Court's going to refer us back. I'm going to have you talk with Miss Blade. I'd like to get it seems like the 506 is pretty high. I'm not sure what that's based on, but we should, based upon her income of $1,400 a month, and Mr. Evans income of $3,300 a month. If you can recalculate that, please. I'll put you back in a room with Miss Blade, and so we can revise this recommendation.
Yes, Your Honor.
Thank you.
According to recalling top of page 2, Madison Blade versus Torian Evans.
Once again, this matters before the court on the plaintiff mother's objections to a referee recommended order regarding child support. This hearing is being conducted via Zoom. The plaintiff, Madison Blade, is present on audio. The defendant, Father Torian Evans, has not appeared. After conferring with Ms. Blade, the court had Ms. Anderson rerun the figures. So we have a revised recommendation, Ms. Blade, which says effective November 1st, 2023, father shall pay child support amount of $434 per month, which is considerably more than what was previously recommended by referee McKee of $286 a month. So the $434 a month will be retro to November 1st, 2023. And just for reference, we're noting that this is based on father having 120 overnights, based upon your testimony that he's on average 10 nights per month, and that your monthly gross income is about $1,400. Dad's is $3,333.33. Do you understand the recommendation?
Yes, I do.
All right. Any objection to the court adopting this?
No.
All right. Court will adopt the recommendation. Thanks for appearing. Again, this increase will go back effective November 1st, 2023. Noting that Mr. Evans did not appear. So that will conclude this hearing. Thank you for your patience this morning.
Thank you for your time.
Ms. Andrus. Thank you, Ms. Andrus, for your attention and your assistance.
Thank you, Honor. I will create that uniform child support order as well.
I appreciate it. It's nice to spell it out so we know in the future how we base it. So thank you. The record this matter is before the court pertains to a pre-trial conference. Subsequent parties have engaged in mediation. Actually, it's an initial pre-trial conference. Subsequent parties have engaged in mediation with Mr. Walker in front of the court this afternoon. This pre-trial is being conducted via Zoom. Attorney Christina Hills is present, representing the plaintiff Heather Straub, and both Mr. Straub both appear to be present. Good afternoon.
Good afternoon, Your Honor.
Good afternoon.
Ms. Hills, the court has been informed that parties have made significant progress this afternoon, but have scheduled to continue mediation on May 1st at 1:30. Is that correct, with Mr. Walker?
That is correct. Both parties are engaging the services of an appraiser, and the amount of equity in the marital home remains our biggest hurdle to resolving the case in its entirety today. We do have an agreement as to most other issues, and I'm happy to put that on the record. We also have reached a temporary agreement pending further mediation and sort of seeing how this agreement goes with respect to the children. This agreement would be incorporated into a temporary order, which would be without prejudice as to either party.
Very well. Mr. Straub, is that all correct?
I believe so.
I'm sorry?
Yes, I believe
Okay.
it, yes.
All right. Okay, so Ms. Hills will state in the record what changes understands to be your temporary agreement. So listen carefully. And after she does, I'm going to ask you to confirm your understanding of that, okay?
Yes, sir.
And I guess before we proceed further, Mr. Straub, even though Ms. Hills is helping to facilitate resolution of this matter, she will prepare what's ultimately called a judgment of divorce. Ms. Hills represents your wife, Heather, so her loyalty is live with Heather. Do you understand that, sir?
Yes, sir.
Okay. Do you have any questions or concerns before we continue?
Yeah, I just want to make sure that what she's saying is actually what we did go through in the court and with the mediation, because I noticed when we were sitting down with the mediation guy at the end, Miss Heather's lawyer and that guy had a hard time making sure that they're on the same page with what we agreed upon in the mediation, and then she's kind of going over it now after we've already agreed on it, and it's kind of confusing.
Okay, so Ms. Hills is going to state what understands to be your agreement. So listen carefully, and you got a piece of paper and a pen there. You have presumably made notes. So listen carefully. Ms. Hills will state what she understands to be your agreement, and then I'll turn to you and ask you whether or not it's a correct statement of your agreement. Okay, Ms. Hills.
Thank you, Your Honor. Your Honor, the parties have agreed that they will have no contact with each other except as to the welfare of the minor children. They will use app close only for communication, except in an emergency. We are going to mediate further with Mr. Walker on May 1st at 1:30. We are going to temporarily and without prejudice agree to joint legal custody. We are not at this time addressing physical custody. Parenting time is going to be on a 50-50 basis. That will start with Mr. Straub having the minor children from Friday, the 15th of March through Monday, the 17th of March. Thereafter, we're going to be utilizing called a modified 2-2-3 schedule. The first Monday, Tuesday, after the 15th through the 17th, which would be the 18th and the 19th, those overnights of parenting time would be with Ms. Straub. Then father would have the Wednesday, Thursday overnights of parenting time, and Ms. Straub would have that following weekend. So putting it in plainer terms, the parties are going to flip-flop the Monday, Tuesday, and the Wednesday, Thursday overnights and alternate the weekends from Friday until Monday morning, generally to school. The person who's starting parenting time is going to be doing the pickup if it cannot be done at school. The exchanges would be in the driveway or curbside, if possible, depending on what's appropriate for the safety of the children. There would be no communication between the parties at the exchanges. That could be done through app close prior to or after the exchange. Mr. Straub has agreed that until he finds his own place, he's going to be living at his brother's home for purposes of his parenting time. That does not mean that he can't leave his brother's home with the children. That simply means that's where he's agreed to live until he finds his own place. The parties would be using the friend of the court holiday schedule unless they otherwise agree in writing. However, the holiday schedule would not commence until Memorial Weekend. So the regular parenting schedule, the modified 223 schedule, would be in place for spring break and Easter weekend. Neither party would interfere with the children's ability to contact the other parent. And
I don't know where you're coming from with this, but I have to stop you here. We didn't agree on any of the stuff that you're talking about here. A lot of the stuff is not what it was written. I'm sorry to interrupt, but you just keep going, and I can't say yes to anything because you've said so much, and a lot of it isn't what we talked about. Sorry.
I'm going to let Mr. Walker take over at this point.
Please.
Your Honor, all I can say is that we did have an agreement when we left my mediation. So far, from what I've heard Ms. Hill state, she has not deviated from that agreement yet.
She said that we didn't agree on the custody, but I thought we had agreed.
You have joint legal, which I believe Ms. Hill stated, but you haven't agreed anything on physical custody, which we didn't talk about physical custody. We didn't agree on anything when it comes to that.
I thought that's what we meant by we each have them every other week.
Yeah, Ms. Hills has not gone over parenting time yet. She will get to that. That's separate.
Okay, I apologize for the misunderstanding.
So, Mr. Straub, we're not dealing with physical custody. It's not necessary. It's just the joint legal means that you make equal decisions regarding the important decisions regarding the welfare of your child or children, like medical treatment decisions, education, so forth. And so we're just addressing parenting time, which is a temporary basis between now and when we come back. Temporary basis sounds like pretty much equal parenting time.
Yeah, that's what I thought it was, and I'm sorry for the misunderstanding. I didn't understand how it was being phrased. I'm sorry.
And again, if in fact we need to tweak this or modify this when we come back on May 1st, we can do that. This is temporary between now and then. All communication via app close, joint legal, which means if the child's with you and you get in the emergency room, you need to immediately notify mom, vice versa.
Yeah, that's fine.
So this is just between now and May 1st. It's temporary, without prejudice. You can, if you want, you can still hire an attorney. You can argue these things, but it sounds pretty reasonable so far. So, Ms. Hills, do you want to go through the parenting time schedule again, Ms. Hills?
Sure. What we call it, in general family court attorney terms, is a modified 223 schedule, whereby the parties would alternate the weekends from Friday through Monday morning. Typically, that would be to school, although we do have times in place for when the children don't have school, and I'll get to those in just a moment. But Mr. Straub would have the weekend of Friday the 15th of March through Monday the 17th of March. Then Ms. Straub would have the 18th and the 19th overnight. So the first Monday, Tuesday would be hers. Then the Wednesday, Thursday would be Mr. Straub's, the 20th and 21st. Thereafter, we're going to be flip-flopping those Monday, Tuesday, and Wednesday, Thursday, so that the following Monday, Tuesday, Mr. Straub would have those overnights, and the following Wednesday, Thursday, Ms. Straub would have those overnights, and we continue to alternate the weekends, Friday through Monday. If there's no school and Ms. Straub is working, then the exchange would be after she is done with work. If there is no school for the children and Ms. Straub is not working, or Mr. Straub is not working once he gains employment, then the exchange would be at 9:30 a.m. or another time to be agreed by the parties, depending on Mr. Straub's work schedule, whatever that might be. So I believe, it is my understanding that Mr. Straub agreed that for the first week of the 50-50 schedule, so starting Friday, the 15th, because it has been a couple of weeks since he's had parenting time with the kids, that he has agreed that if the children ask him to go back to moms, that he's not going to interfere with that for only the first week. After that, it will be, there won't be that provision in place. If the children ask to go back to moms, he does not have to agree to that at that point unless he chooses to. And that's simply something that he agreed to for the comfort of the children, as I understand it. So that is the entire agreement, a temporary agreement as it relates to the children. And then we also do have a partial property settlement that we do wish to put on the record today.
Okay, let's first of all stop there, Ms. Hills. Mr. Straub, so far, as Ms. Hills accurately stated, you're a temporary agreement without prejudice in terms of parenting time between now and when we get back on May 1st.
Yes, that is fine. That is what we agreed upon, and I just thought that was an agreement of the other physical custody. I was mistaken, but that is the agreement, and that's fine.
And this court doesn't deal with physical custody. When the children are with you, you make the decision what time to go to bed. When they're with mom, mom makes the decision what time to go to bed. Those those mundane decisions. The parent and whose possession the children are makes those decisions. All right, so we got to past that point, Ms. Hills, and there's some other agreements relative to the overall divorce action.
There are, and we did have some temporary agreements, orders already in place, and those would remain in effect with regard to the primarily it's the exclusive use of the marital home, as well as the personal liberties injunction. All those prior orders that are not in conflict would remain in full force and effect.
Do you understand that, Mr. Straub?
Yes.
So any
yes,
prior orders which are not inconsistent with this order will continue in full force and effect. Understood?
Yes, sir.
All right. So with regard to the partial property settlement, we are not addressing child support at this time. That is being reserved. We are not addressing spousal support at this time. We are not addressing the amount of equity in the marital home that is owed to Mr. Straub, with the exception of a credit for some marital debt that Ms. Straub is taking on. And we do have a specific number for that. So we would include standard statutory language regarding life insurance. Mr. Straub is entitled to 50% of the marital portion of Ms. Straub's Panera Bread 401k. That would be divided by a qualified domestic relations order. His portion would be subject to gains and losses after the division date, which would be the date of entry of the judgment of divorce. The qualified domestic relations order would be prepared by Ms. Pastrana, and the parties would split the cost of preparation of the qualified domestic relations order and any administrative costs equally. Other than that, each party is awarded the retirement accounts in his or her own name, if any. With regard to real estate, Ms. Straub is awarded the marital home which she owned premarital. She is going to assume the mortgage, indebtedness, taxes, all other expenses of ownership, and will indemnify and hold Mr. Straub harmless from that debt. He is not on the mortgage. I think both parties agree with that. He is not on the deed either. So once the divorce is final, he is going to convey his interest in the property to Ms. Straub by giving her a recordable quitclaim deed. And she is going to pay him a sum to be determined for his share of the marital equity in the marital home. And that amount, whatever half of the marital equity is, that will be adjusted downward by $3,513 as of today's date. That amount will not change. I said as of today's date, but I want to make it clear that number is fixed, and it relates to a credit card, and I'll address the specifics of his use of that credit card moving forward in the debt section. But whatever his half of the marital equity is, that will be adjusted downward by $3,513. With regard to, and I should say, again, both parties have appraisals pending, and we hope to have those by the date of the next mediation with Mr. Walker, so we can get that issue resolved as well. With regard to personal property, parties are going to agree to divide their personal property with some specific exceptions. And as to all of the personal property that I'll mention, each party agrees to pay any debt owing on that property and hold the other harmless from liability on that debt. Ms. Straub is awarded the 2020 Chevy Equinox, the 2011 Chevy Impala, and Mr. Straub has agreed to provide her with the key to the Impala if it is in his possession, and he's agreed to exercise some due diligence in trying to find that for her. Mr. Straub is awarded the 2001 Dodge Ram pickup and the 1983 Starcraft Super Sport boat and boat trailer. He is additionally awarded all of his guns, actually all guns, the 32 and the 40-inch TVs, the leftover solar panels, 2 100-amp lithium batteries, 2 boat motors, and the third being awarded to Ms. Straub, which came to her from her grandfather. His hunting gear, the kayak, the power tools and the hand tools, the fishing gear that's not awarded to Ms. Straub, and the Cub Cadet lawnmower. I don't believe I missed anything there. Ms. Straub will be receiving the generator, the refrigerator and stove, her wedding rings, her fishing poles, the fishing gear that she got from her grandfather, the children's 2 cell phones, once any pending CPS investigation, if any, is closed, and her grandfather's boat motor, as I mentioned. With regard to bank and financial accounts, each will receive all interest in the bank accounts in his or her own name. They do have a Robinhood financial investment account, and Ms. Straub is going to be paying Mr. Straub 1/2 of the value of that account as of the market close on the date of entry of the judgment of divorce. Regard to marital debt, they're each going to be responsible for the debt in his or her own name. Again, that $3,513 credit on the equity accounts for Mr. Straub's share of the marital debt as of this date. And if he is going to be able to continue to use the Cabela's credit card on which he is an authorized user, that card is in my client's name. He will be solely responsible for paying for any charges that he makes on that card as of today's date and moving forward until this matter is final. If he has not paid those amounts that he charges in full to Ms. Straub by the date of entry of the judgment of divorce, then she will be entitled to a further credit against the equity in the home in whatever amount he has charged on that card. This card is nice because it indicates not only the charge that is made, but who has made the charge. So if it is Mr. Straub, it's going to clearly say Charles made that charge with his card. So there should not be any sort of question as to whose charge is whose. But she will be entitled, if he's not already paid her, to deduct those amounts after today's date from his share of the equity in the marital home. As of the date of entry of the judgment of divorce, he has agreed to not use that card at all. Parties have just very recently filed their 2023 taxes, and they are going to split the refund such that Mr. Straub is going to receive the first $2,000 of the total refund, state and federal, and then the parties are going to equally split the balance of the total refund remaining after he gets the first $2,000, and that's to equalize the bank accounts in this case. Parties would acknowledge not receiving any tax advice from attorneys. Tax exemptions for the minor children is they have 3 minor children, and for even tax years, Ms. Straub is going to take 2 exemptions, Mr. Straub 1, vice versa for odd tax years. When there are 2 exemptions, they will each take 1, and when there is only 1 exemption remaining, again, Ms. Straub will get that exemption for even tax years and Mr. Straub for odd tax years. Each would pay their own attorney fees. Ms. Straub would be entitled, if she so chooses, to have her maiden name of Saunders, Saunders, restored to her. And I believe that is the extent of the partial agreement as of today.
Thank you, Ms. Hill. So the only remaining issues would be determining child support, spouse support, as well as Mr. Straub's interest in the half of the marital value of the real estate, correct?
Yes, figuring out what is his half so that we can come up with the appropriate amount with the credits that Ms. Straub is entitled to, correct?
I do have
each party.
I'm so sorry. The other 2 credit card debts, were those also going to be rounded into being removed off the equity amount? Because there's 3 credit cards.
Josh, help.
Thought we were cutting all of them in half.
I did not add those in. You're muted, Josh. I did not add those in, but that
was Ms. Hills, you did add that was part of the initial amount of money, the fixed amount that you had stated that was going to be taken off of what Heather owes to Charles for the equity in the home. That was for for all 3 credit cards plus the $100 extra towards the Cabela's.
The 3515 was just the Cabela's one. That's half of just the Cabela's.
Okay. That's supposed to also be with the Kohl's and the card member services.
All right.
All 3 are supposed to be split equally.
Yeah. Okay. So and that's as of today's date. So Heather, I'll need you to get me those so I can get those figures to Charles. And then we would add those, and for Mr. Straub's 1/2 of those, then we would deduct that. We would add that to the $3,513, which would be deducted from the equity in his share.
I have those amounts unless you just want me to send them to you later.
You can go ahead and state them for the record.
Okay, so the Kohl's one was, oh man, $625.53, and the card member service was $3,221.78.
I'm sorry, say that card member services one again.
$3,221.78.
Okay, so we'll provide Mr. Straub with proof of those account balances as of today. And I think we would just need to confirm with him that he's agreeable with those amounts being deducted as well. His half of those amounts being deducted as well from the equity, his share of the equity in the marital home.
Yeah, I agreed, as long as I get statements to those accounts, because I don't have statements, so I can see purchases.
That's not a problem.
Okay, so I'll figure the math out there and send both parties a letter confirming my understanding of the figures and what we've agreed to today.
Right. Ms. Hills, how will the parties determine the marital value of the real estate? They're both going to submit an appraisal, and we'll try to find some middle ground between the two appraisals, and then look at what the increased value of the home from and after the date of the marriage.
Yes, my client is getting an historic appraisal as well as a current appraisal, so hopefully Mr. Straub will do the same. But yes, we're hoping that we can get some assistance if we need it from Mr. Walker in coming up with a final resolution on May 1st.
Okay. So, Mr. Straub, you understand we basically need an appraiser, unless, of course, obviously, if Heather's going to hire a certified appraiser, you may be comfortable relying upon that appraiser, but if you want your own opinion, then you can pay for it. And obviously, the appraiser needs to determine what the current value is and what the value was as of the date you got married.
Yeah, I'm down to get my own appraisal.
Okay, that appraiser needs to be instructed what you need. It's not just a fair market appraisal. They need to determine, what'd you call it, Ms. Hills, a historical appraisal?
Historic appraisal and a current appraisal, yes.
Okay,
So
yeah,
historical appraisal and a current appraisal. So you need to provide that appraiser with the date of your marriage with respect to this real estate. And obviously, the appraiser going to want to see the home, so you need to communicate with Ms. Straub on app close and let her know the name of the realtor, and so Ms. Straub can make arrangements to have that realtor examine and go through the house. Right. So, Mr. Straub, we've already dealt with on a temporary basis parenting time and joint legal custody, which I'm glad to see. Parenting time is pretty much equal. With respect to the other issues, is that a correct statement of your agreement in terms of the property?
Yeah, Miss Straub can have full uses of the home, and if she wants to buy the home out, I have no problem with that. It's best for the children.
Well, this is an agreement. She's going to keep the home. She's going to be awarded to her. You're going to sign a quick claim deed at time of entry of the judgment. She's going to pay you 1/2 of the marital value of that home, less this figure to be determined on the credit cards. It's the original was what, $3,513.
Yes, Your Honor. I just did the math. The number I come up with now is $5,436, of course, subject to Mr. Straub seeing the statements.
That wasn't the half.
That was half, yes.
Right. So whatever the value that's determined, Mr. Straub, by the appraisals, they're going to deduct $5,436, and she will pay you that difference. What's the time frame for paying that, Ms. Hills?
Good question. Judge, can you pay that within 120 days of entry of the judgment, Heather, in case you need to get a home equity line of credit?
That would be good. Yes.
Okay. 120 days or sooner if she can.
Okay, so Mr. Straub is being suggested she'd have 6 months in which to pay that in order to secure an additional loan in order to come up with that sum of money. Any objection to that?
No, sir.
No?
No
Okay,
objection.
Mr. Straub saying no. And that's pretty typical, Mr. Straub. Their side has a reasonable time frame, 6 months, in which to get that financing together. But again, the other terms of the agreement that would be final in terms of the division of the personal property that was referenced. The
Yes.
pension, each of you keep your own, except you're getting 1/2 of the marital portion of Heather's 401k with Panera Bread as of the date of entry of the judgment divorce. The tax dependency for the children, all those other issues, are those all acceptable?
Yep. And then I didn't know if I caught her, but I also get the $2,000 credit for the $4,000 in Heather's bank account. I'm not sure if she said that.
I did. We take that off the top of the tax refund so that the parties are just splitting the balance of the tax refund after he receives the first $2,000. The tax refund is going to be about $5,300, I believe. Is that correct, Heather?
Yes. Yes.
So yes, you'll get the first 2,000 of the 2023 tax refunds, and the remaining balance will be shared equally, Mr. Straub. But again, if this is your agreement, then you'll be bound by that. We're not going to re-argue these issues later on down the road. Just the limited issues, the value of your home and the real estate, child support and spousal support. Those are the main issues. Everything else has been addressed. Is that all agreeable?
That's agreed.
Okay. Do you have any questions for the court or any questions of Ms. Hills?
No.
Right. Ms. Hills, you want the party sworn?
I do, Your Honor. I was wondering if you
Right.
wanted me to do proofs today in addition to questioning about the partial settlement
Sure.
agreement.
We might as well can take some sworn testimony. Mr. and Mrs. Straub, can you both please raise your right hand to be sworn? Do you both solemnly swear or affirm that the testimony about the given this matter will be the truth, the whole truth, nothing but the truth, so help you God?
Yes, I do.